So let's say your case is over. The trial is over and the jury gave their verdict. Well, what if you think the judge got it wrong, or that the jury ignored the evidence? You can file an appeal. An appeals court reviews decisions from lower courts to check for legal errors and to ensure the law was applied correctly. Appeals courts do not hear new evidence or witnesses. They affirm, reverse, or send cases back to lower courts for new proceedings. The appeals process focuses on legal points rather than facts. It provides a layer of review for parties unhappy with a trial's outcome, aiming for consistent applications of the law. Their goal is to answer to the final standard of proof used in our justice system: substantial evidence. Was there substantial evidence to support the lower court's original decision? Substantial evidence sounds fancy, but it's actually pretty simple. It means there was enough relevant evidence that a reasonable person could use to reach the same conclusion. Basically, even if not everyone would agree, there must be something solid in the record that supports the verdict. If that kind of evidence exists, the appeals court will almost always uphold the decision. If not, they might reverse it or send it back for a new trial. Appeals courts don't retry cases. They review what already happened to make sure it was fair and legal. They're not deciding who's right. They're deciding whether the process and the proof were enough. That's why this burden of proof is so important. It keeps the system balanced, but still allows correction if something clearly went wrong. Think of it like an instant replay in sports. The trial is a live game full of emotion, strategy, and judgment calls. The appeal is the slow motion replay, and the referee looks at the footage and asks, was there enough clear evidence to justify the original call? If there was some credible evidence, the verdict stands even if the replay isn't perfect. That's substantial evidence in action. Let's say someone was convicted of burglary. They appeal, arguing the evidence wasn't strong enough. The appellate judges will look at the trial record, the testimony, exhibits, and transcripts in order to answer the question. Was there substantial evidence that a reasonable jury could have relied on to convict? If witnesses placed the defendant at the scene, fingerprints matched, and stolen property was found nearby, that's substantial evidence. Even if the defense argues it wasn't perfect, the conviction likely stands. But what if the evidence was just one unreliable witness and no physical proof? What if the prosecution's case was built entirely on speculation or guesswork? The appeals court might rule that no reasonable person could have found guilt based on that. That's when the conviction can be overturned. It doesn't happen often, but when it does, it's because the court found that the verdict simply wasn't backed by substantial evidence. In Florida, we saw this with the open carry issue earlier this year. A lower court enforced the state's open carry restrictions and upheld an arrest. On appeal, a higher court stepped in and reversed that outcome, ruling that the law had been misapplied. No new evidence, no new trial, but a standard of proof determined by a higher court in order to correct the legal framework and result in a big change in gun laws. This standard serves two big purposes. First, it protects verdicts that are fair. If the trial had real evidence and proper procedures, it prevents endless retrials and appeals. Second, it corrects serious errors. If a trial was built on weak or missing proof, it gives the appellate court a reason to step in and fix it. It's the safety net that keeps justice from going off balance. You can think of a verdict like a house. If it's built on a solid foundation, even if one wall is crooked, it still stands. If that house is built on sand with no foundation at all, it falls apart. Substantial evidence is that foundation. It doesn't have to be perfect. It just has to be strong enough to hold up the result. A common misunderstanding is some people think an appeal is a second chance to argue their innocence. It's not. Appeals aren't about new facts. It's about checking whether there was enough evidence the first time. That's why having a strong trial defense from the start is so important, because once you're at the appellate level, the rules of the game have changed. Let's take one final look at the full pyramid from start to finish. Reasonable suspicion allows police to stop or question. Probable cause allows police to make an arrest or obtain a search warrant. Preponderance of evidence is the proof that decides most civil cases. Clear and convincing evidence is used when rights or reputations are on the line. Beyond and to the exclusion of every reasonable doubt is the highest standard of proof used in criminal trials. Substantial evidence is used in appeals courts. It's a separate system that checks whether a trial's decision was supported by enough credible proof. From the first police encounter to the last appeal, every step in the justice system is built on the question, how sure are we? And that's what makes substantial evidence such a powerful idea. It's not about redoing the trial. It's about making sure justice was done right the first time. It's not about new evidence. It's about proving there wasn't enough solid evidence in the original case. The more you understand the system, the better you can protect your rights at every level. In our next video, I'll discuss 5 tips you won't want to miss when dealing with a DUI. I'll see you there.